everybody. Well, we want to welcome everybody here to this webinar today. This is an exciting opportunity we have to hear from the U.S. Department of Housing and Urban Development, and we're excited about this. But before we begin, if we can move on to some housekeeping items just briefly. Due to the amount of participants we have registered, prior to this joining, we heard that there's nearly 1,000 people registered. And due to the massive amount that we are expecting, it's going to be unable to answer and have people speak and ask questions individually. So we direct everybody to the lower right-hand portion of your screen to the Q&A portion, wherein you are able to type questions. So when you type in my Q&A, we encourage you to type your questions there, and we will be able to address them throughout the webinar today as best we can. As soon as the webinar ends, which we're projecting to be at 3 o'clock p.m. Eastern Time, so exactly 1 hour from now, we will, all questions that have not been answered, we will be able to download these questions and then issue them and try to get them answered after the fact and post them on an FAQ document, so all the questions will hopefully be addressed in due time. Additionally, this webinar is being recorded and will be broadcast and posted online. So if you're unable to participate in the entire event, or you have colleagues who wish to participate or learn more about it, that's an opportunity for them to get further information. With that, we will move into the portion of this webinar we're very excited to host. We're in Washington, D.C. This is the Washington, D.C. office for the IATMO Group. A little bit about the IATMO Group. We were founded in 1926 in Southern California. It stands for the International Association of Plumbing and Mechanical Officials. And we are the developers of construction codes. And many people know our construction codes due to the fact that our flagship document is a Uniform Plumbing Code. We have the Uniform Mechanical Code, Swimming Pool Code, and Solar Energy Code. And these are all ANSI accredited documents that we move forward with every 3 years. And so that's where we are with IATMO. And we're also very excited to have in the room here is 2 representatives and officials from the U.S. Department of Housing and Urban Development. With that, I will go ahead and provide the introduction. Presenting in today's webinar will be Mr. Steve Johnson. He is the Director of Entitlement Community Division in HUD's Office of Community Planning and Development, which oversees annual funding to over 1,200 cities, counties, and towns nationally. He has over 30 years experience in the Community Development Block Grant Program in HUD's headquarters and in HUD field offices. He has been extensively involved in the CDBG program, regulatory and policy development in areas such as economic development, brownfield development, redevelopment, and the 2009 Recovery Act funding. So we welcome Steve. Additionally, we also have another great presenter, Gloria Coates, who is the Community Planning and Development Specialist in the Office of Block Grant Assistance, Entitlement Community Division. She has held this position for almost 16 years. Most of her workload focuses on issues regarding potential new entitlements, urban county qualification, requalification matters, regulatory reform, and housing. Gloria also addresses inquiries from HUD field offices in Region 4, which includes Florida, Georgia, Mississippi, Alabama, Tennessee, Kentucky, North Carolina, and South Carolina. And with that, we will turn the time over to both of you to present this webinar for us today. Thank you.
Thank you. It's a pleasure to be here. We are excited to see that very close to 1,000 people pre-registered for this. We are delighted by the expression of interest that shows. My name again is Steve Johnson, and we are going to cover several topics here today. For some of you, particularly those who are code enforcement professionals that may not be particularly familiar with the CDBG program, we're going to give a little bit of a general program overview for you. We also realize there are some people who are from HUD and from some of our community development grantees. Some of that may be things you already know, but understand we've got multiple audiences here participating in this, and that's part of the point of this webinar today. So we'll give an overview of how the program works, how funds are selected. Then we will talk a little bit about the eligibility of activities, what sorts of things you can do, and that we will start with that by tying that into what is code enforcement, what's the purpose of it. Then talk about what activities community development block grant funds can be used for. We'll then talk about something called national objectives. National objectives are probably at least as important as making sure that an activity is eligible in this program. Many things are eligible, but you have to also show that it's going to meet one of the statutorily established national objectives. We've got a few other little sidebar comments on things like fair housing and relocation requirements, just for you to keep in mind. We're going to talk about fines from code enforcement activities or inspections and how those are to be treated. We're going to spend a minute talking about a statutory provision that got passed in 2012. It is sunsetted, but some of you may have actually made use of this while it was in existence, and so we want to talk a little bit about that just from the record-keeping perspective. And then we're going to especially talk about record-keeping, because one of the reasons we issued the notice that we recently issued, and one of the reasons we're doing this presentation today, is we're concerned that we've seen some problems around the country with people not keeping the necessary documentations, and some communities have had to pay money back. We certainly want to avoid that happening. So we want to make sure that everybody knows what sort of documents they do need to keep so that they will not have problems. Let's talk a little bit now just about the general overview of the CDBG program. The CDBG program, and by the way, we all eat alphabet soup here in Washington 3 meals a day, so everything has to be an acronym. Bear with us. CDBG is the Community Development Block Grant Program. It's now 40 years old. It was authorized by Congress in 1974 under the Housing and Community Development Act. It was the first major piece of legislation signed into law by President Gerald Ford. It is a combination of some previous programs, some of which you have never heard of, some of which, like urban renewal, you probably have heard of. And it represented a significant change in how the federal government provided funding to local governments for housing, economic development, and community development activities. The purpose, as stated in the law, for the Community Development Block Grant Program is the development of viable urban communities, provision of decent, safe, and suitable living environments, and expanding economic opportunities, principally for persons of low and moderate income. We've got about $3 billion a year for this program. Now, 70% of that money goes to what are called entitlement communities. Those are basically bigger cities and counties, cities of over 50,000, counties of over 200,000 population. 30% of the money goes to states, and they pass the money on to smaller rural local governments. We're going to talk a little bit about states in a minute, but most of the program requirements are pretty much the same. Under the CDBG program, we make annual grants. The amount that each community that's eligible gets is determined by a statutorily set formula that looks at various demographic factors, and that data comes from the Census Bureau. So we make annual grants. It's called the entitlement program because as long as they apply for it, the communities are entitled to receive this money. They're legally eligible to receive it. The communities then are free to carry out a wide variety of community and economic development activities, particularly aimed at neighborhood revitalization, economic development, public facilities, and services. CDBG activities are initiated, they're developed at the local level. This is part of the philosophy of the CDBG program. When it was created, it was a reaction to what was seen as sort of the heavy-handedness of the federal government under the old urban renewal sorts of programs. So this program very consciously puts the power and the decision-making back at the local level where it belongs. So the communities are responsible for identifying what they see as their needs. Communities are responsible for deciding what activities they want to use their CDBG money for. And there must be a citizen involvement in that process, and I'm going to talk about that momentarily as well. So each grantee gets to decide what activities they want to fund. There's a list of 26 eligible activities. We'll show that on the later slide here. But again, it's equally important that each activity has to meet one of the 3 national objectives, and you see these here at the bottom. That it principally benefits persons of low and moderate income. Low and moderate income means 80% of median income. It aids in the prevention or elimination of slums or blight, or it meets other urgent community development needs. Now, a community doesn't just to go out and start spending money. The community has to first decide what its needs and objectives are, and we have a structured process on how you do that. For this program, as well as several other similar programs, communities have to do a 3 to 5 year consolidated plan, and then they do an annual action plan. That tells HUD what the overall needs and priorities are for the community. Then the annual action plan tells us, for this year's money, this is what the community wants to spend its money on. That has to be submitted 45 days before the grantee's program year, and the grantee gets to decide when in the year they want their program year to start. We have 45 days to review and approve the plan. And then there are some other reporting requirements that follow on through the year. At the end of the year, 90 days after the end of the year, the grantee has to submit their annual performance report that tells us what they've actually done in the last year. There are record-keeping requirements beyond just the year-end reporting. HUD goes out and monitors grantees, and we review those annual performance plans to see whether or not the community is carrying out what they said they were going to do. Are they addressing the goals they said they were going to? And of course, are they complying with the inevitable requirements that come with the money? So the citizen participation element is worth pointing out again, because while the community, the local government ultimately is the one that decides what to use the money on, by law, communities have to go out and solicit needs identification from citizens and neighborhood groups to identify what the citizens see as the needs are. You have to publish this for comment. You have to hold public hearings. Not too different from what a lot of federal programs require in that regard. And as a part of that, that's how you develop your consolidated plan that identifies what you want to do over 3 to 5 years. And then the annual action plan I just talked about is your annual statement within that, how you're going to carry things out. Now, let's shift a little bit and talk about what the eligible activities are. And we're going to circle back to this again. Gloria is going to talk about these particular. There are 26 different eligible activities listed in the Housing and Community Development Act, which is our law. Now, not all of them apply specifically to code enforcement. This is a very broad-based federal community development program that's designed to allow communities a lot of flexibility to pick out what they want to spend the money on. So as you can see, some of these things have nothing to do with code enforcement, like home ownership assistance or social services. That's because this program is intended to cover lots of fronts. It was a combination of multiple different programs, and all of those eligible activities in those programs got this, and more have been added on as Congress has identified new needs to meet. So acquisition, rehabilitation, clearance, demolition, public services, infrastructure, code enforcement, historic preservation, economic development, and then planning and administrative costs are some of the major categories. All right, now you can go back. We are going to try our level best not to throw a lot of regulation citations at you today, particularly if joining our audience here from the code enforcement end of things, we realize you're familiar with your own language and lingo. Your industry, you're not going to have the community development program laws and regulations memorized by any means, but when we do occasionally talk about specific eligibility citations, we just want to make sure you know what we're talking about. The statute, and is the Housing and Community Development Act of 1974. Sometimes we'll just say the statute or the act or the HCDA. When we're giving you a citation of specific regulations, it is going to be specifically the implement CDBG program regulations. The ones that matter most here are basically the discussions of eligible activities and than the national objectives. Now, the state program has its own separate regulations. It's run ever so slightly differently. And so you'll see at the bottom there are separate state CDBG program regulations. This is where states provide the funding. This is probably a good time to talk just a little bit about how the state program differs from the entitlement program that makes funding to the big cities. In the state CDBG program, again, this covers rural areas, places that qualify directly to get an annual grant under the entitlement program from HUD. States essentially step into HUD. This was one of the first sort of new federalism block grants that turned power and the states in the 1980s. So the states essentially step into HUD's shoes. They oversee grants that they make with our money to units of local government throughout their state. States have a lot of decision-making responsibility and flexibility here. They do not have to follow exactly the same requirements the entitlement cities and counties do. States put together a process in which they identify how they're going to distribute the money to the local government, because the state doesn't get to keep it themselves. They must award the money for local governments to actually carry out activities. Now, a lot of states use a competitive process, but they don't have to. There really is, in some ways, no one state CDBG program, 50 different state CDBG programs, because every state does it a little bit differently. And then the local governments that are receiving money from the state report to the state. HUD does not have a contractual relationship with them. Ultimately, the state that oversees those grants. Let me point out one thing about code enforcement to give you a sense of this. Talk about what it is. So just give you an idea of the dollar amount we're talking about. The CDBG program as a whole in a year. About, and 70% of that goes to big cities and counties, about $2 billion. About $120 to $150 million a year of that gets spent specifically on code enforcement activities. That's about 5% of all the money that goes to the entitlement cities, and states spend much less on code enforcement. It's well under 1%. States tend to spend a lot of money on basic infrastructure instead. That is their choice, but it remains an eligible activity in the state program. So let me give you now Gloria Coates, our community development specialist, who helped write what we issued last fall. And she's going to talk about what code enforcement is and then go through what kinds of costs are eligible. Gloria.
Thank you, Steve. Good afternoon, everyone. First, we'll start off defining what is code enforcement in accordance with our regulation and our statute, because the state program primarily for eligible activities uses Section 105 of the Act for their eligible activities, while the citations that you viewed are for the entitlement program. We've defined it in the entitlement program. There are costs that grantees incur for inspections of code violations and the enforcement of their code. And these costs include the salaries of the inspectors carrying out the inspections and related expenses that they incur, as well as legal proceedings. For example, if a fine is assessed and the person wants to appeal such a fine. However, on the entitlement side, the cost of correcting those code violations is not a part of what is eligible under the citation you see here, 570-202C. But the code enforcement inspections and enforcement must be carried out in areas that are deteriorating or have deteriorated, with such code enforcement together with public or private improvements to be made or rehabilitation or services are expected to arrest the decline of the area. Now, in the state program, as you see, it's much shorter. The use of CDBG funds for code enforcement, the areas like entitlement have to be deteriorated or deteriorating areas. There is a difference here that you may not notice, but I'll point out quickly. Section 105A3 does not have the limitation in there that the cost of correcting the violations, and then 202C is not eligible, but in the state program there's no such, as you see, no such restriction of correcting the violations in accordance with Section 105A3. Okay, now different jurisdictions across the United States define code enforcement in different ways. However, 202C is the regulatory authority they have to follow. Some jurisdictions call code enforcement the prevention, detection, investigation, enforcement of violations of statutes and ordinances that affect the public health, the public safety, and welfare. Some also, in addition to that, include the maintenance and preservation and value and appearance of residential units, commercial units, and industrial buildings within its boundaries. Some jurisdictions focus on things like neighborhood cleanliness, public advertising displays, lawn care, environmental concerns, for example, tires, stacked tie, and the condition of motor vehicles that appear on their streets. Okay, for purposes of the CDBG program, code enforcement is defined as a process where local governments gain compliance with the ordinances and regulations that they have regarding health codes and housing codes, land use codes and zoning ordinances, sign standards, and uniform building and fire codes. And to point out, the CDBG program expects the major focus of code enforcement, assisted with CDBG funds, to be on health and safety issues in buildings and structures versus neighborhood cleanliness. However, it's not prohibited. Supplemental efforts to address such code violations, for example, the condition of a vacant lot, signs advertising different things like events that people post on boards, and the condition of motor vehicles on the streets. Those are allowed with CDBG. However, it has to be in conjunction with efforts that involve buildings. So it can't be their primary focus. You have to have a building or structure. And it should only be a very minor part of the grantee's code enforcement program. One of the issues that we had, Steve touched on earlier, with regard to the use of CDBG funds for code enforcement, a lot of grantees may not have the time distribution records and documentation to show that the code enforcement was carried out in an eligible area, which is one that is deteriorated or deteriorating. And because they do not have the proper documentation, a lot of them have experienced monitoring findings, and disallowed costs. And usually when costs are disallowed, the grantee has to repay those costs with non-federal funds. So we want to emphasize that our grantees must ensure that their records and their documentation show that the activity is not only eligible, that it meets a national objective, but that the costs are allowed, the costs must be reasonable, and also grantees have to ensure that the time spent on conducting code enforcement in CDBG eligible activities are accurate. Okay, what is the purpose of code enforcement, you may ask? Actually, it's to protect the public health, safety, and welfare. Also to encourage homeowners and tenants to maintain the appearance and value of the housing units that they occupy, and to protect the health and safety of persons that utilize buildings such as public facilities, and also to reduce neighborhood crime. Briefly, a study was done many years ago, the broken windows theory, that demonstrated that areas where there are broken windows that aren't repaired look as if they're not being cared for, so that encourages people to do further vandalism to those structures, or to think that no one cares about what this area looks like, so they may do a lot of destruction that may, result in environmental and other issues. Okay, now we're going to briefly discuss the eligible code enforcement costs. The salaries of code enforcement officers that work in CDBG eligible areas. I want to point out that this does not mean the entire jurisdiction of the grantee. It has to be an area that is deteriorated or deteriorating. I just want to emphasize that. Also, if a jurisdiction doesn't have a department that carries out this type of work, they must procure in accordance with 8536 of the regs, even though now most of that is in 2 CFR Part 200, grantees are allowed for an additional year to use the standards in 8536. But that's the standard they can use to procure code enforcement inspectors, specialists, or a company, or even hire another unit of government to conduct their code enforcement inspections for them. They may also use CDBG to lease a vehicle, not purchase, but lease a vehicle to conduct such inspections. Also, the OMB circular allows use allowances for vehicles that are purchased with other funding sources when used in the carrying out of a CDBG eligible activity. Uniforms and coveralls, if they are a job requirement, those may be paid for with CDBG funds for the inspectors carrying out code enforcement only in CDBG eligible areas. Same thing with the handheld computers and tablets, because they have to be able to record the information that they find as they're conducting their inspection. However, they cannot charge this exclusively to CDBG. It has to be in proportion to the time that they spend conducting CDBG assisted inspections for CDBG purposes only in CDBG eligible areas. To enforce codes, which is also eligible under 202C, the legal and code enforcement hearings, when someone may appeal their fines, the cost of actually processing and issuing the citations, using their mail, but I guess they could be sent other ways. Hearing officers who hear these code enforcement fine appeals, in proportion to the time they spend hearing and deciding appeals from code enforcement citations, only from CDBG-assisted code enforcement inspections, not as a general code enforcement. They must be CDBG-assisted in CDBG-eligible areas. And also, if grantees incur legal fees as part of the legal proceedings in proportion to the time spent only on CDBG-eligible code enforcement, the legal fees may also be an eligible CDBG cost. Briefly want to touch out what is not eligible under 57202C, which is the language where code enforcement is. The public or private improvements or the rehabilitational services that a grantee must also provide to arrest the decline of the area. That has to be carried out in conjunction with the code enforcement inspections and enforcement. They can't just do these inspections and enforcement and do nothing to correct the violations. They do not have to use CDBG to fix up the area. They may also use another funding source if they like. However, depending on what is found, if it's a public improvement, it may be eligible under 201C. If it's a private improvement, it may be eligible under 203. This is usually for your commercial industrial structures. Rehabilitation may be eligible under 202A. It depends on who it is, you know, because as Steve said, every activity must meet one of 3 national objectives. So even if it's eligible, it may not meet a national objective. Neighborhood cleanup campaigns may be an excellent way to clean up an area. However, they are not eligible under 202C as part of cleaning it up. It may be eligible as a public service under 201E. And public services, every grantee except, there's a list of exceptions, which I don't have on it. But most grantees must adhere to a 15% public service cap, which is 15% of that year's grant plus 15% of the preceding year's program income. It's also not eligible for grantees to conduct code enforcement inspections and enforcement in every neighborhood in this jurisdiction. I'm sure there's no particular city or town in the United States where the entire jurisdiction is deteriorated or deteriorating, which is what's necessary here. Also, general government expenses are not eligible because grantees are not allowed to use CDBG for general conduct of government costs. So in this case, CDBG can't be used to carry out code enforcement inspections and enforcement in non-CDBG eligible areas or areas that are not deteriorating or deteriorated. It's also important that areas that are inspected with CDBG funds, they have to meet the local or state law definition of deteriorated or deteriorating. There are standards under slum blight in the national objectives section of the regulations, 208B1 for entitlements and 483C for states. Some of those standards may be used to determine if an area is deteriorated or deteriorating. However, there are limitations to that, and here we have a couple of them listed. A grantee just can't determine that all the public improvements are in a general state of deterioration and use that as a reason or justification to conduct code enforcement inspections in private property in certain areas. Also, the local state definition of deteriorated or deteriorating may have criteria in it that has nothing to do with the the physical condition of the built environment. Or structures. Remember, CDBG assisted code enforcement primarily focuses on structures.
Yep, thank you, Gloria. There's a couple of questions that people have already come in with, and actually right now is a good time to make sure we reinforce one point. Maybe 2 points. One, I know some people are already saying, well, what about neighborhood cleanup programs? That may be run out of the code enforcement department. That is not going to be eligible specifically as code enforcement. Do keep in mind, we're trying to focus on one slice out of all the activities that are eligible in the CDBG program. There are probably ways to find anything you want to do eligible. This may not be the right category for some of what you're talking about. Doing neighborhood cleanup campaigns or coordinators is not code enforcement per se, because it is not focusing necessarily on eliminating code compliance issues in structures. We've also had some people asking about what about mowing properties or snow shoveling or things like that. You have to be careful. There are certain things that the law says just are not eligible. General government operations are not eligible to use CDBG money on. So if it was a matter of mowing public rights-of-way on streets, no, that's not going to be eligible under any circumstance. Mowing properties that people are not maintaining, if you're placing a lien on the property, you may be able to recoup that. But that's not really the code enforcement itself. That's solving the code issue that has been raised. And as Gloria said, those are not necessarily eligible as code enforcement costs. They may be eligible elsewhere. And a really important question here as we transition to talking about the national objectives, which is what I mentioned earlier. Somebody said, well, who defines what the target areas are, the deteriorating neighborhoods, and how often do they have to be requalified? The grantee determines what areas they want to work in. It is up to the grantee using state or local law to identify what areas meet state or local definitions of being deteriorated or deteriorating so that you can use CDBG money on it. And there is no set time limit per se on that. But certainly, if I were a HUD monitor and I was coming out and looking at a city and they were using a definition that had last been updated in 1980, I think I might say, well, why do you think it's still deteriorated now? We would expect you to sort of make sure that you're keeping that current because things change, neighborhoods change. You may have had great success in turning the neighborhood around. And at some point, you may have to determine, guess what, it's no longer deteriorating. It is rebounded, and we need to move on to some other neighborhood. Now, let's talk about these mysterious national objectives. As we said earlier, most everything can probably be found to be eligible for CDBG funding under one way or another, but it also has to meet a national objective. And that is often more challenging than determining that something is eligible. Our law, the Housing and Community Development Act, which created this program, specified 3 different national objectives that every activity has to address at least one of these. Either it principally benefits low and moderate income persons, it prevents or eliminates slums or blighting conditions, or it's addressing other urgent needs. Now, we spell out those in greater detail in our regulations, and that's what we're going to cover here in the next few slides. It's also important to remember Congress said that one of those 3 national objectives is the most important of all, because Congress said that a grantee must use 70% of its money towards activities that benefit low and moderate income persons. So the other 2 national objectives, eliminating slums and blight or addressing other urgent needs, are useful, but you're capped at only being able to spend 30% of your money on those kinds of activities. So it is always in your best interest to first find a way to say that it is principally benefiting low and moderate income persons. And we have multiple categories on multiple criteria on how a grantee can show that an activity is principally benefiting low and moderate income persons. Certain of those work much more for code enforcement than others. There are a couple we're not even going to talk about because they simply would not be eligible or applicable at all. So the first is, and probably one of the 2 that really matters for most communities, is that you are carrying out the code enforcement activity in a defined neighborhood that is primarily residential and where 51% or more of the people are low and moderate income. That is called benefiting low and moderate income persons on an area basis. The community defines the area. We provide data that shows what areas, what neighborhoods by census tract and block group are at least 51% low income persons. So we sort of give you the data to tell you where those areas are. You are carrying out these activities to benefit the entire neighborhood, all the residents. It's not that you're only doing code enforcement on properties that are owned by low-income persons. By taking care of code enforcement violations, you're benefiting everyone in the neighborhood and the neighborhood as a whole. That's the whole point, and that is why most communities are going to use this national objective to demonstrate how they're carrying out their code enforcement program. It does not have to be limited to just housing. Your neighborhood has to be primarily residential, and we go out of our way to avoid trying to define what is primarily residential. Yes, there can be industrial property in there can be some parkland, etc. We try not to define primarily residential because it's quicksand. You'll never extricate yourself from that, sort of argument. So you do not have to limit what you're doing to just residential properties. It does not have to be limited to code enforcement only on houses owned by low-income persons. You can do multifamily properties. You can do single-family properties. You can do commercial buildings. You can even do code enforcement with CDBG money on publicly or nonprofit-owned buildings. So you go out and you do code enforcement inspections on a publicly owned daycare or a senior center and you find problems, well, that's eligible if it's in this neighborhood that qualifies. Now, a few of you, particularly if those of you who are grantees, may say, well, I thought we had a different percentage and not just 51%. There are a few communities that are pretty well off that still qualify for our money. They are actually allowed to meet a lower standard than 51% of the people being lower income, because in some of these communities they have very small neighborhoods that even have any concentrations at all. If you are one of these so-called exception communities, talk to your community development person at your local city hall or county. They will know whether they are or not. But for most people, most communities, the minimum is that the neighborhood has to have at least 51% lower income residents. Okay, now, here's the second national objective that really matters to people, which is prevents or eliminates slums and blighting conditions on an area basis. Again, here's this term area basis, but now we're not talking about benefiting low-income persons per se. You're really talking about addressing the conditions, the physical conditions of the neighborhood. Again, we do not define what the area is. The grantee, you all define, draw the boundaries of what the area should be. It has to be a designated slum or blight area. It has to meet state or local laws or definitions. You do not necessarily have to declare it under state or local law to meet our requirement. Some communities don't want to go and, put the official imprimatur that this neighborhood is blighted. They don't want to do that for public perception reasons. That's fine, as long as it meets the definition. But as Gloria pointed out, we do not rely just on state or local definition, because some state or local laws, they're created for multiple purposes. Sometimes they include things like improper zoning, or they allow undeveloped land to be financed. So we say, okay, it has to meet a state or local definition of slum or blighted or deteriorating. And then we have some additional criteria, and that's the second of those bullets. I'm not going to read all of those. At least 25% of the properties have to, in this defined area, have to meet one or more of those conditions. Obviously, things like vacancies, deterioration ring very well here. Some things, suspected environmental contamination, that may or may not be specifically a code issue. So properties have to meet those definitions. And then the other key part of addressing the slum and blight national objective is that the activities that you're carrying out have to actually address one of the conditions that led to this area being determined to be deteriorated or blighted or to be a slum. So like Gloria pointed out, you could use the fact that the public facilities are in a general state of deterioration as the basis for why the area is blighted. But if what you're trying to do here is address physical conditions of buildings, there's kind of a mismatch with saying this area is blighted because all the streets and the infrastructure is falling apart. But never mind, that's not what we're going to do. We're going to concentrate on buildings. You've got kind of a mismatch there in terms of what you're saying the needs are and what you're spending the money on. So you do have to think carefully about lining these national objectives up with what you're trying to do. You can use this definition of deteriorated or blighted, if you want to, as your local definition of a deteriorating area for designating what's an eligible code enforcement area. These are not exactly the same things. I realize, particularly if you're coming from the code enforcement professional side of our audience, you don't know all of this terminology exactly. So don't get too tripped up and realize there is information that will help you understand this better online. If you want to do code enforcement, it has to be in a deteriorating area. It does not have to be a designated blighted area unless that's the only state law or local law you have. You can use this definition. It doesn't mean that they have to be exactly the same areas. You don't have to use this provision to meet a national objective. You could also do the low and moderate income area criteria. So don't get too hung up. These things sound very similar. They're not exactly the same, but there is some conscious overlap here. All right, let's move on to the third national objective, which is urgent needs. This will only apply in a few cases, probably, but you should know about it at least. Areas that have had some sort of serious health or safety issue come up, a tornado, a flood. You may be able to do this as an urgent need, particularly if you can tie the need for code enforcement into maintaining public health and safety. If you're needing to do code enforcement in an area that's had a tornado or a hurricane, you want to make sure that people are actually staying in and not staying in deteriorated buildings or buildings that are unsafe. You have to certify that the urgent need came about within the last 18 months, that it is a serious and immediate threat to the health and welfare of the community. You do that, and you can use code enforcement to meet the urgent need national objective. But again, you have to show that you're spending no more than 30% of your money on activities that are meeting something other than the low moderate income benefit. Now, again, here's just a little more information about the urgent need certification. I'm going to move on to one other point here. And this is not the heart of our discussion. Just keep in mind that there are fair housing, civil rights laws at the federal level that apply to this program as well as several others. You want to make sure that you're aware of these, that if you're carrying out a code enforcement activity, you're not accidentally doing something that's in violation of some of these requirements. For example, and this may seem like an extreme case, but you want to make sure that you're not somehow ending up targeting just certain groups, ethnic groups or language groups or something like that in your code enforcement. If you have brochures, policies, procedures, if you're doing public meetings, keep in mind you may have to make that available in more than one language, because if you're going to a neighborhood that's all recent immigrants and you hand them a brochure in English, they're not going to have any idea what you're telling them, that you're going to come and do code enforcement in the neighborhood. And then they're going to be very startled when people start knocking on the doors. So make sure you do that. There's also one other requirement called the Uniform Act, the Uniform Relocation, Real Properties and Acquisition Policies Act of 1970. It's called the Uniform Act for good reason, because it's much shorter. If you displace people intentionally as a result of code enforcement, you could end up having to pay displacement and relocation benefits to them. Rarely would that really be an issue. If you think you might have a situation where you think you're going to actively cause displacement of people, talk to the HUD field office. They can put you in touch with the relocation specialist in advance to make sure you don't do something that has significant economic consequences for you later. All right. I'm going to hand it back to Gloria. We're going to change topics a little bit now, and this is really about what do you do when you generate revenue from fines or from enforcement. Gloria.
Thank you, Steve. Yes, this is an important topic because there may be grantees that do not quite understand how fines that are assessed should be treated. The first thing that usually happens is because CDBG was used for the code enforcement, the first thing they said, oh, it's program income. It was generated from the use of CDBG funds. However, that's not the case. If you go to this regulatory citation here and you read what is program income, you will see that fines do not constitute program income. They can be treated either in one or two ways depending on what the purpose of the fines are. They can either be treated as applicable credits to the CDBG program or as general revenue. Okay. This citation here is from the new requirements. We call it the Omni or Super Circular, OMB Circular, and this defines applicable credits. It's receipts or reduction of expenditure type transactions that will offset or reduce the cost of carrying out the activity. Usually there are rebates. You know, you may get a refund for something. For example, you're installing windows, then you get a rebate on those, or storm doors, then, you get something back. You have to treat it as an applicable credit. But they have to be related to allowable costs. In other words, CDBG-eligible code enforcement in this case. However, to treat them as applicable credits, you have to look at the cost of the inspections for the code violations and the code enforcement, which includes, as we said, maybe inspector salaries. Those have to be either wholly or partially paid for with CDBG funds. And it also depends on what the intended purpose of the code enforcement fine is. Usually you'll find that in local state law or manual. Now, if the purpose for those fines is to recover the cost that the grantee incurred for code enforcement activities, without regard to the source of funds, it could be CDBG or some other funding source, but the intended purpose must be to offset some of the costs that they incur in carrying out code enforcement, whether it's CDBG assisted or not. However, if that's not the case, they may be treated as general revenue. And in this case, the purpose has to be not to recover the cost of code inspection enforcement. Also, if they were not paid with CDBG funds and the amount of the fines exceeds the cost paid for with CDBG funds, in those instances, code enforcement fines may be treated as general revenue, which means they have no CDBG requirements tied to them. Okay, now to briefly mention, as Steve mentioned before, the 2012 statutory provision on code enforcement that sunset in 2014. Actually, our Housing and Community Development Act was amended by the MAP 21 Act to add a new section to our statute, provision 27, and actually it allowed the use of CDBG funds to actually supplement existing state or local funding that was being used for administration of building code enforcement by local building code enforcement departments, for example, to increase the amount of staff members, to provide staff training on, for example, updated codes or new codes, to increase the professional capacity of the code inspectors, to increase their competence via training, to pay the costs of certification or department accreditation, and any capital expenditures that are specially dedicated to the administration of the building code enforcement department. Okay, there were some specific, and I'll try to go through these quickly. MAP 21, when it implemented this new provision 27, it required a match using non-federal funds. And in the CDBG program, normally for any of the other eligible activities, there is no match requirement. So without reading this to you, you can see that depending on what the population is and the percentage of CDBG funds that may be used would determine how much that match would be. So you can refer to this slide to determine how much the match had to be. However, really it's not important anymore because this provision sunset. Matter of fact, in July of 2014, but there are some grantees that may have actually carried out code enforcement under this authority. Another thing that was allowed that I didn't mention before was code enforcement training to be treated as an activity delivery cost rather than a program administration cost. That's a whole nother, okay. But 202C, which is the code enforcement regulation, and Section 105A3, which is used by the state, CDBG funds can be used there to pay the salaries of code enforcement inspectors. So you don't have to use that particular provision for salaries. You can use these provisions depending on whether you're an entitlement or a state grantee. Some of the other activities that were mentioned here may be considered activity delivery costs, training, for example, and under these authorities, there's no match required and there's no sunset. Now I want to briefly touch on record-keeping requirements. They're located at 570-506 of the regulations, and for states, 570-490. Records that they must have, especially if they're using slum blight, they have to have the state local law definitions of deteriorated or deteriorating in their files. And they have to be able to show a description of the condition of the area where CDBG funds were used for the code enforcement. They use low-mod area benefit or on an area basis. They have to be able to show the boundaries of the area that was determined to be deteriorated or deteriorating. They use slum blight. They have to be able to show what areas were designated as slum or blighted under state or local law, or show that a minimum of 25% of the buildings in the area were in a general state of deterioration, or has a lot of vacant properties, abandoned properties, or chronic high turnover. And for urgent need, the grantee has to be able to show that it posed, the buildings inspected posed a serious and immediate threat to the health and welfare of the community in which it's located, that the disaster, flood or hurricane or tornado happening within 18 months of the grantee certification or sooner, and that the grantee had no other funding source to pay for those code enforcement inspections. For the state program, the unit of general local government makes the certification, and the state makes the determination that the criteria was met for urgent need. And the entitlement program is actually the grantees themselves. They have to also show other activities that they're carrying out that will arrest the decline of the area, since they must be done in conjunction to arrest the deterioration. They have to have salary and timekeeping records, as indicated earlier, for their code enforcement inspectors, and the descriptions of the areas that they conduct in their code enforcement. Legal proceeding costs have to be documented, and salary costs, by having time distribution records in place. As Steve said before, HUD does monitor, and they will be looking for this type of documentation by grantees carrying out code enforcement. The next couple of slides are some helpful links to information that may be beneficial to you. If you don't have a copy of the code enforcement notice, as we call it, here's a link to it. Also a list of the exception grantees, the grantees that are allowed to use a percentage for area benefit of less than 51%. They have to have information that shows how they meet the needs of persons who have limited or no English proficiency. And in the state CDBG program, here's the guidance on their record-keeping requirements. Also, just general information on entitlement and CDBG programs. Formula allocations for 2015, you can find out any grantee in the United States, how much they were awarded for 15. Also, the CDBG contacts, which are your usually your local community development departments or planning department or something similar. Also, the list of HUD CPD field officers, where you can also get additional information. And last but not least, also to access the CDBG program laws and regulations, there's an electronic link. Question? That's
Well, thank you very much for this wonderful webinar. This has been very informative. we've provided several questions, and due to time, we won't be able to get to them all, but we'll turn some time over to cover the questions that we have in front of us, and so I'll turn the time over to Steve.
Okay. Yeah, a lot of very good questions here. Some of these are obviously coming from people that work directly with CDBG money on a regular basis, and some probably are coming from people in the code enforcement departments who may not be familiar, and they've got excellent questions. One question is, how do you define a deteriorating area? It's really up to the community. There is no set national standard. That's part of the local decision-making and discretion process. You can use the definition that HUD uses for what is a blighted area, but you don't have to. A very good question here. Can code enforcement be qualified as meeting the low and moderate income area benefit national objective if the community is 55% lower income overall? Keep in mind, code enforcement can only be carried out in specific areas that you've determined at the local level to qualify as deteriorated. So the fact that the city as a whole is more than half the residents are low and moderate income, that's one thing, but you've got to show that the area that you've designated that you're going to work in is at least 51% lower income persons. So just the fact that the city as a whole qualifies isn't good enough. You've got to look at the specific areas you're working at. Somebody was asking about what sort of ongoing monitoring impact expectations are there. Other than the data where you indicate how many buildings you've addressed, how many code enforcement actions you've taken, we don't actually at this point have long-term performance measures that we track for code enforcement activities. We've had a number of communities that have been specifically asking us to do that. We are taking some look at what our reporting requirements are now and where they ought to go in the future, and we will take that into consideration. There are a number of communities that think we ought to do more to track this because they've got good information they'd like to be able to tell the funders in terms of what they're doing. Can code enforcement activities be directed to specific buildings in eligible areas, or must they be directed towards all buildings in an eligible area? That's a very good question. You, the grantee, as the code enforcement professionals, you decide what buildings you need to be doing inspections on. If your policy is you go do inspections of every building, or if that's how you design your program, you go right ahead. If you're going to focus on areas where based on complaints or something like that, that's how you select who you're going to inspect. Again, that's your decision to make. We don't get involved in that decision. Are commercial corridors that are surrounded by lower income residential areas eligible, either under the low and moderate income area benefit national objective or under the slum and blight prevention national objective? It's up to you to define the boundaries and establish them. You have to have sort of a logical basis for why you've defined that area. Yes, you may have commercial corridors that serve that specific residential area, and if that's how you've defined the area and it makes sense, fine, go ahead, and you can then address whichever national objective you think makes sense there. I would caution that if you're trying to say, well, here's, the major street for our major city, if this was Pennsylvania Avenue in Washington, D.C., and you're saying, well, yeah, but there's this residential area behind it. Yeah, but there's no connection in that residential area and that major street. Your local field office might say, well, how are you defining that as one cohesive neighborhood? Aren't they really unrelated? We had one question here, let's see if I can find it quickly, about designing software. Because we mentioned that you could use CDBG money to buy computers, handheld devices, laptops, etc. And then somebody said, well, what about the cost of designing or purchasing software to go in those? Keep in mind that the extent to which you can charge these costs to the CDBG program is a little bit dependent on exactly who's using it and how you're doing it. If you're going to use CDBG money to pay for specific tablets or handheld devices, those have to be assigned to the people that are working in specific designated target areas. You can't just go out and buy a bunch of new laptops for the entire code enforcement department, where any person can use any laptop, just take whatever one's, on top of the stack. If we're paying for specific pieces of equipment, we need to know that only the people that are working in the designated target areas are using those because we're paying for it. That's one of the problems we've seen in the past. Likewise, I think the problem with if you're wanting to design or buy software is you're not going to do that just for the 3 people that you're supporting with CDBG money to work in 3 designated target areas. You're probably going to want to use that software for everybody. If you had a cost allocation plan that dictated how you distribute those costs, you may well be able to charge some portion of that software acquisition or development cost to the CDBG program based on how you're splitting it up. You want to go talk to your finance department about cost allocation. I'm not in a position to certainly describe them in detail, and I'm no accountant. So possibly you can check with your finance people. It may be trickier than you think. Whether it's worth your while to do so is ultimately your decision and your finance department's decision. How much longer? Yeah, we're a little past 3 o'clock now.
Past 3. There's one question. There's several questions coming in, so we're not going to be able to address them all. There's one that says, can you please, are CDBG-funded coded enforcement activities limited to enforcement-related only structures?
You determine what buildings you wish to be doing code enforcement on. There doesn't have to be any other tie to CDBG funding for you to go in and choose specific properties or neighborhoods to work in. I'm not sure if there's some other part of that question I'm missing. It's ultimately your decision, your choice. Just make sure that you maintain the documentation on how you made that decision, why you picked that neighborhood, what the boundaries are, what the physical conditions are, and have time records showing that William Smith spent 4 hours in the northeast target area doing nothing but code enforcement, and thus 4 hours of his time gets charged to CDBG. That's really the most important takeaway we can leave to people. Right. Document, document, document.
Very important. Great. Well, we've had several, due to time, we're already almost 10 minutes past the hour, and we have several questions. So if there's anything else you guys want to address, if not, what we'll do is we're gathering all questions being asked and typed into the Q&A portion. Those questions will then be extracted and answered and put into an FAQ document. So as we mentioned before, this presentation will be made public. It will be put online so people can review the document and also the FAQ documents as well. With that, thank you very much for your time and coming here today and presenting this webinar. And as you can see, from the attendance, there's great interest there. So we appreciate your time today. Thank you.